Welcome to Rotherham Sendias workshop around permanent exclusions from maintained schools, academies and pupil referral units. The information within this workshop is only going to be appropriate if your child attends a maintained school, an academy or a pupil referral unit. You'll find information about school exclusions on the following link at the top of this sheet. The first thing to do if your child has been permanently excluded is to check what type of school your child attends, because if it's a maintained school, an academy or a pupil referral unit, then the information in this is relevant. You can check which type of school your child attends by the second link on the slide. So what is a permanent exclusion and who makes the decision to exclude a child permanently from school? Permanent exclusion is the most serious sanction a school can give if a child does something that's against the school's behaviour policy. It means that the child is no longer allowed to attend the school and their name will be removed from the school roll. There is a process for removing a child from a school roll, and this will be described in this video. The decision to exclude a pupil permanently should only be taken in response to a serious breach or persistent breaches of the school's behaviour policy, and where allowing the pupil to remain in the school would seriously harm the educational welfare of the pupil or others, such as staff or pupils in the school. Only the head teacher of a school can make a decision to permanently exclude a pupil on disciplinary grounds. A head teacher could be the head of a maintained school, the teacher in charge of a pupil referral unit, or even the principal of an academy. If the head teacher is absent, then the person appointed as acting head is also able to make the decision to exclude on disciplinary grounds, and this may not necessarily be the deputy head teacher. So what are the things that a head teacher has to consider before making a decision to exclude a child permanently? Any decision of a head teacher, including suspension for a fixed period amount of time or a permanent exclusion, must be made in line with the principles of administrative law. So it needs to be lawful, reasonable, fair and proportionate. When establishing the facts in relation to a suspension or a permanent exclusion decision, the head teacher must apply the civil standard of proof. So that means it's on the balance of probabilities that it's more likely to be fact rather than the criminal standard of beyond a reasonable doubt. This means that the head teacher should accept that something happened if it's more likely that it happened than it did not happen. The head teacher must take account of their legal duty of care when sending a pupil home following an exclusion. And head teachers should also take the pupil's views into account, considering these in light of their age and understanding before deciding to exclude, unless it wouldn't be appropriate to do so. The head teacher also needs to consider the special educational needs or the disability of a child. So the Equality Act 2010 requires schools to make reasonable adjustments for disabled pupils. This duty can in principle apply both to suspensions and permanent exclusions, and to the disciplinary sanctions that are imposed. There's also the Children and Families Act 2014, and governing boards must use their best endeavours to ensure the appropriate special educational provision is made for pupils with SEN, which will include any support in relation to behaviour management that they need because of their special educational needs. Schools should engage proactively with parents in supporting the behaviour of pupils with additional needs, and where a school has concerns about the behaviour or the risk of suspension and permanent exclusion of a pupil with SEN or a disability, or if they have an EHC plan, it should, in partnership with others, including where relevant the local authority, consider what additional support or alternative placement may be required. This should involve assessing the suitability of provision for a pupil's SEN or disability. If a child is making use of SEN support through the graduated approach, or if they have an EHC plan. Where a pupil has an EHC plan, schools should contact the local authority about any behavioural concerns at an early stage and consider requesting an early annual review prior to making the decision to suspend or permanently exclude. Although this may be challenging if the incident is just a one-off incident and it may not be directly related to a student's SEND. For those students with SEN but without an EHC plan, the school should review with external specialists as appropriate whether the current support arrangements are appropriate and what changes may be required. This may provide a point for schools to request an EHC assessment or a review of the pupil's current package of support. So what might be the reasons why a head teacher might exclude? Although the following list is not an exhaustive list, it provides some examples of the sorts of incidents that can lead a head teacher to make the use of their power to exclude a pupil permanently. It can either be physical assault against a pupil or an adult, verbal abuse or threatening behaviour against a pupil or an adult, use or threat of use of an offensive weapon or prohibited item that's been prohibited by the school's behaviour policy, bullying, racist abuse, abuse against sexual orientation or gender reassignment, and abuse relating to disability. There may be times where a head teacher makes a decision to exclude a pupil permanently or through a suspension because of something that's happened outside of school time or outside of the school grounds. A pupil's behaviour outside school can be considered grounds for a suspension or permanent exclusion. The school's behaviour policy should set out when a pupil's behaviour outside of school premises may lead to disciplinary sanctions. Some examples of this may include taking part in any school organised or school-related activity, travelling to or from school or in the vicinity of the school, wearing the school uniform or is in some other way identifiable as a student of the school, for misbehaviour at any time, whether or not the conditions above apply, that could have repercussions for the orderly running of the school, or pose as a threat to another student or member of the public, or could adversely affect the reputation of the school. When notifying parents about a suspension or permanent exclusion, the head teacher should set out what arrangements have been made to enable the pupil to continue their education prior to the start of any alternative provision. For any permanent exclusion, head teachers should take reasonable steps to ensure that work is set and marked for pupils during the first 5 school days where the pupil will not be attending alternative provision. So how do you find out about a permanent exclusion? Whenever a head teacher permanently excludes a pupil, they must, without delay, notify parents or the pupil themselves if they're over the age of 18 of the permanent exclusion and the reasons for it. This should be in person or by telephone in the first instance to allow for a discussion to be had and to allow parents to ask initial questions. However, the head teacher must also, without delay, after their decision, provide parents with the following information in writing: the fact that it's a permanent exclusion and the reasons for it, the parent's right to make representations about the permanent exclusion to the governing board and how the pupil may be involved, parents' right to make a request or to hold the meeting via the use of remote access, and how and to whom to make this request to, how any representation should be made, and as there is a legal requirement for the governing board to consider the permanent exclusion, that parents or an excluded pupil, if they're over 18, have a right to attend a meeting, have a right to be represented at that meeting at their own expense, and to bring a friend. Written notification of the information above can be provided by delivering it directly to the parents, leaving at their usual or last known home address, or posting it to that address. Notices can be given electronically if the parents have given written agreement for this kind of notice to be sent in this way. If a child has a social worker, or if they're a looked after child, the school must also inform the social worker and the virtual school head of the exclusion as well. Some important information for you to be aware of. Where a permanently excluded pupil is of compulsory school age, the head teacher must also notify the pupil's parents of the days on which they must ensure that the pupil is not present in a public place at any time during school hours. These days are the first 5 school days of a permanent exclusion, or until the start of any full-time alternative provisions put in place. Any parent who fails to comply with this duty without reasonable justification commits an offence and may be given a fixed penalty notice or be prosecuted. The head teacher must notify the parent of the days on which their duty applies without delay, and at the latest by the end of the afternoon session on the first day of the permanent exclusion. Is anybody else informed about the exclusion? The head teacher must also, without delay, notify the governing board of any permanent exclusion, including where a suspension is followed by a decision to permanently exclude a pupil, any permanent exclusion which would result in the pupil missing a public examination or national curriculum test. The local authority must be informed as well without delay of all school exclusions, regardless of the length of them. And for a permanent exclusion, if a pupil lives outside the local authority area in which the school is located, the head teacher must also notify the pupil's home authority of the permanent exclusion and the reasons for it without delay. Some useful things for you to consider at this point. What was the incident that took place? Are you clear from both the school and from your child's account of what happened? Do the accounts differ? Did your child have access to the support specified in an EHC plan or the SEN support plan at the time of the incident? When were you notified of the exclusion? Were you contacted the same day? Were you then notified in writing without delay? Was the letter detailed, dated, and did it provide you with all the information necessary, including sources of support and advice? You can find more information about what should be included in those letters in the guidance on the link that was provided on the second slide. So your child's been permanently excluded and you've received notification from the school about this. So what happens next? The local authority must arrange suitable full-time education for the pupil to begin from the 6th school day after the first day of the permanent exclusion. This will be the pupil's home authority in cases where the school is in a different local authority area. In most circumstances in Rotherham, you'll be contacted by the Exclusions team. You can find more details on the local offer website, and the link to that is here. You'll notice when you go on the link that if you scroll down to point 5 on the right-hand side, you'll find the Exclusions information, or you can contact the Exclusions team on Rotherham 808 004 or by email exclusions@rotherham.gov.uk. The school should collaborate with the local authority when the pupil might be eligible for free home-to-school travel, arranged by the local authority to the place where they will be receiving their education. In addition, where a pupil has an EHC plan, the local authority may need to review the plan or reassess the child's needs in consultation with parents with a view to identifying a new school placement. Provision does not have to be arranged by either the school or the local authority if your pupil is in their final year of compulsory education and they don't have any further public exams to sit. Following a permanent exclusion being issued, you will know that the Governing Board will have to meet. Governing Boards have a key responsibility in considering whether the excluded pupil should be reinstated or not. They should consider this within 15 school days of being served notice of the exclusion, and they would do this by calling a meeting. Where a permanent exclusion would result in a pupil missing a public exam or a national curriculum test, there's a further requirement for a Governing Board. It must, so far as is reasonably practicable, consider and decide on the permanent exclusion before the date of the exam or the test. If it's not practical for sufficient governors to consider the reinstatement before the exam or test, the Chair of Governors, in the case of a maintained school, may consider the suspension or permanent exclusion alone and decide whether or not to reinstate the pupil. The following people must be invited to a meeting of the Governing Board and allowed to make representations or share information. So that's the parent of the child or, where requested, a representative or friend, the pupil if they are 18 years or older, the head teacher, a representative of the local authority in the case of a maintained school or pupil referral unit, the child social worker if the pupil has one, and the virtual school head if the child is a looked after child. The Governing Board must make reasonable endeavours to arrange the meeting within the statutory time limits, so that's 15 school days from when they were notified of the exclusion, and must try to have it in time that suits all relevant parties. However, its decision will not be made invalid simply on the grounds that it was not made within these time limits. Taking into account the pupil's age and understanding, the pupil or their parents should also be aware of their right to attend and participate in the Governing Board's meetings, and the pupil should be enabled to make representations on their own behalf if they wish to do so. Where the Governing Board is legally required to consider the reinstatement of a suspended or permanently excluded pupil, they should not discuss the permanent exclusion with any party outside of the meeting. They should ask for written evidence in advance of the meeting, including witness statements and other relevant information held by the school, such as those relating to a pupil's SEN and the pupil's school record. They should, where possible, circulate any written evidence and information, including a list of all those who will be present to all parties, at least 5 school days in advance of the meeting. This is usually called an EP1 document. They should allow parents and the pupil to be accompanied by a friend or a representative at their own expense. Where a pupil under the age of 18 years old is to be invited as a witness, the Governing Board should also seek parental consent first. They should invite a pupil's social worker if they have one, and if the pupil is a looked after child, They should also invite the virtual school head to attend. They should comply with their duty to make reasonable adjustments for people who use the school and consider what reasonable adjustments should be made to support the attendance and contribution of parties at the meeting. For example, if a parent or a pupil has a disability with mobility or communication needs, that has an effect upon their ability to attend the meeting or to make representations. And they should also identify the steps they will take to enable and encourage the permanent excluded pupil to attend the meeting and speak on their behalf, such as providing accessible information or allowing them to bring a friend, taking into account the pupil's age and understanding, or how the suspended or permanently excluded pupil may feed into their views by other means if attending the meeting is not possible. Some points to help you prepare for the Governor's meeting. Ensure that you're clear when and where the meeting will take place and who will be there. Make sure you have enough travel time so you don't feel rushed on the day. Consider the appropriateness of your child attending too. You may ask for their attendance to be at some of the meeting if this is more appropriate for their needs, or you may feel it's not appropriate for them to attend at all. If this is the case, you may wish for them to write a statement to share at the meeting. If you have caring responsibilities for younger siblings, consider this in advance so you're able to attend and give the meeting your full attention. Take time before the Governing Board meeting to read all the information you've been sent. Check the information that you've been sent includes other relevant information, such as SEN support plans or EHC plans, behaviour policies, witness statements, including a statement from your child too. Make a note of any inconsistencies in the paperwork or any differing accounts of the incident in witness statements that you may wish to raise or explore in the meeting. Consider what outcome you would like. If you don't want your child to attend the school again, then be prepared to share this view. Make a note of any questions you may wish to ask about the incident at the meeting. And consider your own emotions in readiness for the meeting. You may wish to take some water or tissues if you feel this may be needed. Consider taking support into the meeting too. If you feel this is needed, then please communicate this clearly with the clerk of the meeting in advance to ensure your supporter is clear what their role is and the appropriate approach to take. So where the Governing Board is legally required to consider reinstating a permanently excluded pupil, they must consider both the interests and circumstances of the suspended or permanently excluded pupil, but also that of the other pupils, staff and school community. The Governing Board must also consider any representations made by or on behalf of the parents or the pupil if they're over 18 years old, the head teacher, the pupil's social worker if they have one, if the pupil's looked after, the virtual school head, and the local authority in the case of a maintained school or pupil referral unit. The Governing Board should ensure that clear minutes are taken of the meeting as a record of the evidence that was considered by the Governing Board. These minutes should be made available to all parties on request, and the record of discussion should state clearly how the decisions have been reached, which a clerk should be present for. The Governing Board should ask all parties to withdraw from the meeting before making a decision. Where present, a clerk should stay to help the Governing Board by reference to their notes of the meeting and with the wording of the decision letter. So what might be the options that come out of a Governing Board meeting? In the light of its consideration, the Governing Board can either decline to reinstate the pupil, which means keeping the pupil excluded, or direct a reinstatement of the pupil immediately or on a particular date. The Governing Board must notify parents, the head teacher, and where relevant the local authority, the pupil's social worker and or the virtual school head of its decision and the reasons for it, and that must be in writing and without delay. Where the pupil resides in a different local authority area from the one in which the school is located, the Governing Board must also inform the pupil's home authority. If it decides against the reinstatement of a pupil who has been permanently excluded, the parents are able to request an independent review. So some things for you to consider at this point. Did the Governing Board provide notice of the meeting? Was the meeting arranged within the timescales, which was 15 school days from the notification of the permanent exclusion? Was all information circulated to all parties within the timescales, at least 5 school days before the meeting took place? Did all parties join the meeting at the same time? Or, for example, was the head teacher sat in the meeting room before you all arrived? Were all parties provided with time to speak and make representations? Did the governors ask relevant questions of all parties? And did the governors explore any difference of opinions, anomalies in the witness statements, or differing recollections of the incident? Were the governors acting in an impartial manner, free from making their own opinions of the incident? Were the governors involved in the incident or the decision making at the time of the exclusion being issued? And was the local authority representative invited to speak, or provided with time to speak for a maintained school or pupil referral unit? Did everyone leave the meeting together? If the governors have made the decision not to reinstate the pupil, the governing board must ensure that a pupil's name is removed from the school admission register. They must only do that if 15 school days have passed since the parents were notified of the governing board's decision to not reinstate the pupil, and if parents have not made an application to the independent review. The parents have stated in writing that they will not be applying for an independent review, or where an application for an independent review has been made within 15 school days, the school must wait until the review has been determined or abandoned and until the governing board has completed any reconsideration that the panel has recommended or directed it to carry out before removing a pupil's name from the register. Thank you for listening to our workshop around permanent exclusions for maintained schools, academies and pupil referral units. If you now wish to consider an independent review at the Governor's meeting, please take a look at our other video around independent reviews for permanent exclusions.